There's a lot of people who have a disability insurance policy that they got through work. And if that's what they have, and they need to make a claim on that policy, they really don't have an insurance claim. They have what's known as an ERISA claim. And that's what the focus of my practice is. Oftentimes what happens is someone's at work and something happens. They get sick, they get hurt. For whatever reason, they can't work anymore, and they end up making a claim on their employer-provided long-term disability plan. Sometimes the Human Resources Department, where they work, helps them initiate the claim. Sometimes their doctors help them initiate the claim, but the claim is made, and as far as that person knows, the insurance company is simply paying their disability claim. And they don't really have a hint that there's anything wrong until they receive a denial letter in the mail. And then once they receive the denial letter, that's when the panic starts in, and that's when they call me. The denial letter will often say many things. Sometimes these denial letters be 8, 9, 10, 15 pages long. It'll list the provisions of the policy. It'll list all of the efforts that the insurance company has reviewed when it came to its decision to deny. And it's written in a way that oftentimes they look very, very convincing. Well, you don't really know whether the matters in that denial letter are valid until you get a copy of the entire file and you verify it. Because sometimes what happens is the decision is made to deny a claim, and so the insurance company sits down with the file and begins to look through the file to find justifications to support a decision it already made, a decision to deny. Well, the first thing they need to do is just come and sit down and talk with me and tell me their story. They come to me with the denial letter in hand, and sometimes I'll read that denial letter. Sometimes I don't even want to read the denial letter until the client tells me their story. Because usually what I find is that if a client has come to me, if the client's claim has been denied, and yet they've taken the time to find an attorney and call an attorney and get an appointment and come down to the attorney's office and sit down and talk to me, the client usually has a pretty good reason for feeling like he or she's been wrongly denied. And I want to hear what that reason is, because I'm not going to find the facts that support the client's claim in that denial letter. That denial letter is only going to contain the facts or the inferences that the insurance company believes supports a denial. So I need to hear the other side before I can begin to make a decision as to whether or not I can help that person. If they have a chronic illness or a chronic condition that has already prevented them from working, they need to make an honest assessment as to whether they're going to be able to go back sometime in the next year. And if the answer is no or probably no, then what they probably need to do is go ahead and file for Social Security disability. The Social Security disability process can take a long time, and there is a 5-month window that the person receives no benefits from the Social Security Administration, even if they're fully qualified. So they need to apply for that to get that process underway. Another thing that makes Social Security disability so important to people who have ERISA long-term disability claims like those that I handle is that eventually that long-term disability carrier is probably going to deny their claim and kick them off of its rolls. And when they do, these people lose their health insurance. And so now, not only are you not receiving any income, you don't have any insurance to pay for your medical care that you need. Well, if you qualify for Social Security disability after 2 years of qualification, you're eligible for Medicare. And for many of my clients, that's the only type of health care they can eventually get, is Medicare. And so they need to get the process started right away so that they're using up their 2-year window of time to get to the point where they'll have medical coverage through Medicare. As soon as a client learns that their case has been denied, they should call us. It doesn't cost them anything. They can come in, they bring their denial letter in. Usually what I do is I get a release signed from them, I order their record directly from the insurance company, and I can review the whole file and decide whether or not I think I can help this client. and it costs them nothing to find out whether I think that I can help them.